Hello and welcome to Calm the Farm podcast, where pharmacy business meets legal wisdom, minus the headache. In each episode, we share practical legal tips and real-life examples to help you run your pharmacy with confidence. I'm your host, Sarah Stoddart. Thanks very much for joining us. Welcome back to another episode of Calm the Farm podcast. Today we're going to keep with our theme of leasing and talk about what happens when you sell your business and the lease needs to be assigned. Now, in my line of work, I see people refer to this as reassignment, assignment, transfer. The correct terminology is assignment or transfer, depending on the state in which you're located. It's not a reassignment in any circumstances at all. So when you are selling your business or the time has come, I guess, for you to move on from your business and you're not closing it down, if you do hold a lease for your business premises, the lease needs to be assigned or transferred. And I'm going to use those terms interchangeably through this episode. Now, your contract and your lease are your key documents for this process. So, of course, your contract is going to set out your relationship or your agreement between the buyer and yourself as the seller in terms of what is to happen in relation to many things, but for this episode, your lease. So your contract is going to say, does the buyer want to negotiate a new lease, which is not the topic of this episode, or does the buyer want an assignment of the existing lease? Now, if they want an assignment of the existing lease, that means that the existing lease is assigned or transferred to the buyer as it is. So the buyer steps into your shoes as tenant, as though they had been named in the lease as tenant from the get-go. So that's an assignment, and that's your contract sets out what it is that the buyer wants. It's also possible that your contract will say that the buyer wants an assignment but also wants some amendments or variations. Again, I'm not going to go down that path for the purposes of this episode. I'm just focusing on the assignment or transfer journey. The other key document, as I mentioned, is going to be your actual lease, because it's going to have a clause in it that says what happens if you want to assign your lease. So you need to dig out those two documents, and even if you're not in the process of selling at the moment, it's probably worthwhile digging out your lease anyway and having a look at this. So in your lease, you're going to have a clause which probably says that you can't assign or transfer the lease without the landlord's consent, and the consent cannot be unreasonably withheld. In addition, it's going to set out a number of conditions that need to be met in order for the landlord to consent. Typically, those conditions include things like asking the landlord for consent for a certain period of time before the actual assignment or transfer is due to occur, which is usually on the settlement date. It'll also say that the parties need to enter into a deed, which is very normal. It probably also has something in there around the financial status and business status of the buyer, or it might be referred to as the new tenant. And what the landlord is usually looking for there is for the buyer to have, hopefully, enough financials and business standing to be able to carry out the lease obligations. So what that actually means is that the buyer coming in as the new tenant needs to have obviously the ability to fulfill the financial obligations under the lease and pay the rent, etc., and also enough business experience to be able to conduct the business. Now, it is possible that your lease says that the buyer or the incoming tenant, new tenant, needs to have financial status and business experience at least equal to the outgoing tenant. I hope your lease doesn't say that, because if you are a seller, it is possible that your experience and financial status well exceeds that of the buyer, depending on the circumstances. So hopefully when you negotiated your lease, you had that clause changed so that they just have to have the financial and business standing to be able to operate the business and carry out the lease, and that there's no actual comparison to you. So the key point here is that you're going to have a clause in your lease which actually sets out the process. Now, when you are transferring or assigning your lease, there's going to be things that need to happen before you can actually go to the landlord. So normally the contract needs to be signed. Depending on what state you're in, there's going to be disclosure obligations, and the parties have to give certain documents to each other by a certain period of time. And then when that process has been completed, you can go to the landlord. If you don't complete that disclosure process, if such process exists in your state, and you go to the landlord early, there can be implications for you as the seller. One of the biggest implications in Queensland in particular is that the landlord does not have to release the guarantors. So if there is a guarantor, and we spoke about that a couple of weeks ago, and you don't comply with the disclosure obligations under the Retail Shop Leases Act in Queensland, the landlord doesn't have to release the guarantor, and the guarantor remains on the hook for the term of the lease, even though it's been transferred or assigned to the buyer. So the moral of the story there is that it is very important to make sure you comply with the disclosure obligations before going any further to your landlord. When that's all done and your contract's signed and you're up to the part where you are assigning the lease, you then, as seller or as seller solicitor, need to make a request to the landlord for the lease to be assigned. You make that request in writing, formally, attaching the documentation relevant to the assignment, and of course with reference to the terms of the lease. Typically what happens then is that the landlord or the landlord's agent responds. They may request some information. Now, the information we see requested most typically is information, of course, on the buyer, which might include their CV or resume, together with their financial information, so statement of assets and liabilities, as well as some references, both personal and business references. So if you're a buyer or a potential buyer listening to this episode, it is worth having that material prepared and put together so that you can provide it in a timely fashion when requested by the landlord. That's particularly so given that the process of assigning the lease is usually one of the processes that takes the longest in a transaction. So get that information ready. The landlord would ask for it. You give it to the landlord. The landlord then makes assessment of the buyer or the new tenant and hopefully comes back and says that consent is granted. If they don't consent, it's worth exploring that a bit more because they can't actually unreasonably withhold consent. And in some states, there's also time frames in which consent needs to be given. If you've got a green light from your landlord or landlord's representative, typically what then happens is that the landlord's lawyer will prepare a deed of consent to assignment of lease. That is a formal document which sets out the terms of assignment and obviously the conditions of consent. Those conditions at that point in time will include obviously the signing of that deed, but also is likely to contain other things like that the buyer needs to provide updated security, insurance, etc., and that the outgoing tenant or the seller needs to pay rent up to date, and what have you. So the parties typically negotiate the terms of that deed via the solicitors, and once it is in final form, it is signed by the parties. In addition to the deed of consent, it is also very normal for a transfer of lease to be prepared. Now, the landlord may or may not be a party to that document, but that document, particularly if your lease is registered on title, is a very important document. It is what will affect the formal transfer on title. So that's the documentation that is prepared. Once that goes back to the landlord, the conditions are satisfied, the landlord will then sign, and obviously the deed is then circulated in final form. Usually the assignment doesn't take effect until the settlement date. It is important to check how assignment date or transfer date is defined in the deed, and then onwards you go with your transaction. So it is a process. It's a process that needs to be carefully followed and followed with advice from your lawyer and also with reference to both the contract and lease. Good luck with your next assignment of lease, and sing out if there's any questions.